Well, good evening, everyone, and thank you for joining us. I know that it's busy out there, and it's a beautiful evening. You're here in Anchorage, so we're excited to learn about trust. We've had Amrit with us before to do a training, and she's a great presenter, a lot of information. So if you have questions, raise your hand, put it in the chat box. I'll oversee the chat box and we can ask questions along the way. So we just want to make sure that you get your questions answered and you learn a lot. So Amber, I'll let you go ahead and take the mic, introduce yourself, and go ahead and start with your training.
Hey, so my name's Amrit Kaur. I'm an attorney in Anchorage. I've been actually practicing law 40 years. I do regular estate planning, probate, and then Medicaid eligibility, a lot with long-term care for nursing home folks. But I've been doing special needs trust in estate planning almost since the beginning of practicing. I've got a slideshow. The slides are very dense because I send it to Lisa afterwards and she can email it out to you as a resource for you to look back on over if you have questions later. So I'm going to go ahead and start sharing my screen. I do have, at the end of segments, I have a slide where I specifically stop and ask for questions before we go on to the next type of things. So, but if I'm moving along and you have a question right then, as Lisa said, please feel free to go ahead and put your hand up or chat so we can catch it while it's fresh. Tonight, what I was asked to talk about was ABLE accounts, special needs trusts, and Miller Trust. And so the focus was on achieving financial eligibility for Alaska Medicaid. Okay, so Medicaid, as you probably know, is for providing medical coverage for needy children and adults, aged, blind, and disabled people. It's jointly state and federal funded, which means that the laws are different in every state. So what I'm talking to you about tonight is what we do in Alaska, but if you have a relative in another state, it might not be what they do. And so it's not like Medicare is 100% federal funded and the law is the same all over the country. But Medicaid, there's like a smorgasbord of different things that states can pick from. So every state has a different program. Alaska has more than a dozen types of Medicaid programs. So I'm focusing only on programs that I think are relevant. My understanding is you're all parents or guardians of children who are in the public benefit system or will be. I understand there may be a couple of professionals that have joined, but mostly the focus, but we're focusing on Medicaid that would be relevant for as your kids turn 18 if they're not already. So the main type of Medicaid that you will run into is for SSI or Adult Public Assistance, APA recipients. This also covers disabled children under 18, but it's the main program for disabled adults. And then there is SSI for disabled adult children, so it's still SSI, but it's for kids who were on SSI and then one of their parents dies, retires, or becomes disabled, and then they are able to start drawing on their parents' Social Security benefits. And so they start getting Social Security disabled adult child benefits. And so that slightly switches the way Medicaid treats their case. And then there's waiver related Medicaid and working disabled buy-in Medicaid, which I have a couple of clients on that who started out on IDD waivers or adults with physical disabilities because they're physically paralyzed when they were minors, and they have switched into this working disabled Medicaid. So this program is available, and so I wanted to bring it up in case this applies to any of your kids. that if they are able to earn enough money, if they're able to work and earn money that puts them over the income limits for APA and regular Medicaid, there is this option to buy in to the Medicaid program. They would actually pay premiums to continue their Medicaid coverage. And it can be their income, or if they've married, it can be a spouse's earned income. And this is a program that allows them to remain eligible for Medicaid, even though there's more money coming in to them or to their household than they're allowed to have under regular SSI APA related Medicaid. And there are two tests for it, the family income as well as the individual's unearned income. And I note here, we're going to talk about Miller Trust later on, but the Miller Trust can be used for either prong of that to achieve income eligibility. So if the family's income is over 250% of the federal poverty guidelines, which is $3,694 this year for a family of one, or $5,134 for a family of two, you could use a Miller Trust to pull the income down. Or if the unearned income, which would mean Social Security benefits, basically exceed the refused cash limit of $1,751 or the special long-term care limit of $2,829 per month, they could use a Miller Trust to pull themselves into the Medicaid buy-in program. So these are the general rules that apply to these categories of Medicaid, the SSI, APA related, refused cash, working disabled. So single people are allowed $2,000 in countable resources. If a couple is applying, even if only one of them is applying, they can have $3,000 of resources. So there is a marriage penalty. It's not $2,000 per family member. They don't count, of course, the house, the home they live in, a burial plan and plot. They also don't count some term life insurance, certain other assets. And for working disabled Medicaid, the resource limit is higher. It's $10,000 for an individual and $15,000 for a couple. So if that is an option, it also allows them to have more money in countable resources. So resource eligibility is applicable every single month that someone is receiving SSI or Medicaid, and that's for as long as they're on the program. If they are found to have been over the resource limit, Medicaid doesn't do anything. They only disqualify someone prospectively, and they don't seek repayment for Medicaid services provided when they were over-resourced. However, SSI requires full repayment of the amount overpaid, and it normally reduces benefits 10% until repaid. But I had a colleague recently in the last couple of weeks reach out and say they actually closed somebody's SSI case completely. And so that is also something that SSI could do. Resource eligibility is determined on the first moment of each month, which literally is 12:01 a.m. So if their Social Security or other income comes in on the first of the month, they're not over-resourced because it's not coming in at 12:01 a.m. It's coming in sometime during the course of the day. And so they're not over-income or over-resourced unless they're actually over-resourced at midnight the night before. So this month, February 29th, by midnight, they would need to be under $2,000 to be resource eligible on March 1st. And Medicaid only looks at this resource eligibility once a month. So if you're over on the first of the month, you're ineligible for the entire month. And so what we're talking about tonight is, well, what do you do if you have too many resources? What can you use that allows Medicaid to disregard those resources? And so the three main vehicles are ABLE accounts, special needs trusts, and pooled trusts. And so ABLE accounts are only for people whose disability began before age 26. And I note here it's going up to age 46 in a couple of years. But it's intended exactly for your kids who have been disabled since birth or soon thereafter. And so it's, intended for people who, it began as something for people who were disabled at an early age. And ABLE is achieving a better life experience. And that's what ABLE stands for. And so special needs trusts are probably the ones you've heard about the most. And therefore, people who have they must have a disability determination. And then the pooled, they can only be funded as long as you're under 65. So the day you turn 65, you can't put any more money into a first party special needs trust. And the pooled trust is for someone of any age with a Social Security disability determination. So that can be used by someone who is over 65. And both of those two trusts, the special needs and the pooled trust, can be used for excess income, just like a Miller trust can. And we'll talk about that after we do all these asset trusts. So for an ABLE account, you don't actually have to have a Social Security disability determination like you do for the other two types of trusts. You just have to be able to certify that you have a medically determinable impairment meeting statutorily specified criteria, or that they're blind and the condition began before age 26. And the person opening the ABLE account is certifying that that condition exists. It's not being reviewed by the ABLE account company, and it's not being reviewed at that point by Social Security or Medicaid. The person needs to have the records to confirm that the disability existed before age 26 in case they are ever audited, but no one is checking it up front. It's self-certification. And so there is an annual limit on how much can be put in, and it's the same as the IRS gift exemption amount, which has been going up $1,000 a year the last few years. So as of January 2024, it's up to $18,000 that you could put into this. And those work great for saving PFDs, gifts from family members, like if their grandmother leaves them, a gift, a lifetime gift, or a small inheritance. Because I used to have to do trusts all the time when people would get a $10,000, $20,000 inheritance from a relative. And so you could put up to $18,000 of an inheritance or other income like that into the ABLE account each year, but it's not from every source. That's the total amount from every source that can go in. So you can't put in 10,000 from one thing and 10,000 from another in the same year. You would be over the limit. And then if the ABLE account owner, your child, is working and does not have an employer-sponsored retirement account, they can save an additional $16,990 in addition to the 18,000. So if they're working, they can also save more money. So that's $34,990 they could potentially put in a year between gifts and wages. I don't know if it's just an oversight because every other year there's been a new number, but I checked the manual again today and it's still not showing a new 2024 amount. It only went up $90 from 2022 to 2023. It's not like it goes up a lot. And then in terms of how much can accrue over time, for Alaska Medicaid, you can have up to $400,000 in the trust or the ABLE account and still be on Alaska Medicaid. But if you reach that point, but when you reach 100,000, SSI will suspend their SSI coverage. As with all of these asset trusts, Medicaid is allowing a vehicle to disregard excess assets during the person's life so that they can receive the benefits that will help enhance their quality of life, take care of their medical needs. But the catch is at their death, the funds in the account have to go to reimburse the state up to the amount of Medicaid assistance that was actually provided. These accounts can be transferred to another qualified family member. So if you have multiple children eligible for benefits, they would be able to transfer this account to another family member rather than having to repay Medicaid. And the ABLE accounts are very popular because well, for a couple of reasons, but one of them is this: qualified disability expenses are much broader than with a special needs trust or a pooled trust. And the main thing that is the big change is housing, that with most Medicaid qualified vehicles, you can't pay food and shelter expenses from the qualified vehicle. And with the ABLE account, you can. And so you see the list of general, base housing and then basic living expenses. So as long as money is taken out and used that month for those expenses, it doesn't impact their benefits. And so we frequently authorize a trustee of one of the other trusts to set up an ABLE account, which allows for these expenses to be paid, these broader categories of expenses like rent. There is a limit to one ABLE account. You can't have different relatives setting up, like this is a 529 type plan, just like the college tuition and stuff are, but you can't have multiple 529 plans. You can't have every relative setting up an ABLE account like you can a college savings account. They're limited to one account. And it's not like you go to First National Bank and open up the account. The state has contracted with a program administrator because it is a 529 type account. Alaska uses the Fifth Third Bank, but if you want to open it in another state that allows non-residents to join because you think they have better investment options, or for some other reason, maybe there's family members there too, you can open an ABLE account somewhere else, but you just can only have one for the person wherever that one is. And I put in the link to the Alaska site that takes you in to set up the account. The distributions, of course, can only go to the designated beneficiary. You can't pull out money and give it to one of your other kids or yourself or something. If the beneficiary has capacity to manage funds, they could be an authorized signer. So it can be a good way, if it doesn't have a lot of money in it, or depending on how good they are at managing their money, to allow them to do some money management. Just because you're a signer on an account does not make you the owner of the account. In Alaska, no. The question is, if you don't want to use if you don't want to use the Fifth Third Bank, which is actually in, I think, Ohio. I was so excited. I was on a trip and said, oh my gosh, there's like a brick and mortar Fifth Third Bank. They really exist because we don't have them up here. But the answer is no. In Alaska, you can't. That is, if you use Alaska ABLE, you have to save with that institution. And they have investment things that will put you in the stock market or mutual funds and different things. So it isn't just like all you can do is open a savings account and buy a CD. They do have investment opportunities. But if you want a different financial institution managing it, you'll need to check with states that allow non-residents to join their ABLE programs. And so I note at the bottom that what I mentioned before, that the asset trust these could be used in conjunction with the asset trust. But an important thing to note is that even though, like earlier I said, they could put their earnings in it, if their earnings actually push them up to where they need a Miller trust between their earned and unearned income, you can't use the ABLE account to deal with excess monthly income. You can only save extra earnings in the ABLE account. And so when we get to Miller Trust, you'll understand that maybe more if you're not familiar with it. But there are income limits for the programs too that we'll get to. So I'll roll on to the other qualifying asset trusts. So these are, the ABLE accounts and these trusts are dealing with excess resource or assets. So the special needs trust, as I mentioned before, is for people under age 65. The pooled trust is for persons of any age, under 18 or over 65 is fine. And but the person must have a Social Security or a state-only disability determination. And verify this. So, I said with the ABLE accounts, it's self-certification. With these trusts, it's got to be spelled out up front. So in the special needs trust, you actually have to put the date of the most recent Social Security redetermination of disability or state-only determination in the trust document, or Medicaid will reject it. And so if sometimes kids are evaluated when they're 18, and then you get a letter that says, unless something changes substantially, we may never look at this again. I got a client shared a letter with me a couple of days ago that said we'll look in like 5 to 7 years or 7 to 9 years. I can't remember which, but it was a substantial period of time. They used to review them every 3 years, but they don't do that anymore. And so if you go to do one of these trusts, the lawyer is going to say, hey, I need that date. And you may be going back and looking for a letter that is years and years old. So I really encourage you to be very organized as your kids turn adult, in particular, if you're their guardian, you're their legal guardian, that you're very organized about keeping all your correspondence that you receive from Social Security and Medicaid related to their cases, because you never know when you're going to need it again. Can't tell you how many times we've had to send someone down to Social Security to get this date. And so you want to try to avoid that happening if you can. These trusts can receive both income, excess income, and excess resources. And so they can hold real and personal property, income producing assets. So if someone inherits a stock portfolio, settlements from personal injury cases, if slip and fall, or if they were disabled by someone else injuring them, these are the kind of trusts that are set up to hold those settlements. If they're not going to spend their back pay for disability benefits within the 9 months that it's excluded, those funds can be put in here. Permanent fund dividends, native dividends that only come out like quarterly or whatever, those can all be saved in here. And again, this trust is required to pay Medicaid back up to the amount of Medicaid provided at their death. And so these trusts can be created by the person themselves if they have capacity, the person's parent while they're a minor, or the grandparent while they're a minor. Once they're an adult, you have to be their legal guardian to create one of these trusts for them. You can't do it once they've turned 18. You can also have a court do it. That used to be what we had to do. The individuals weren't allowed to create them for themselves. So if they didn't have a legal guardian, then we had to have the court do it. And now we hardly ever do that. The expenditures have to be made in accordance with the rules of the program for which they're eligible. So it just depends on, but mostly it's no food or shelter can come out without impacting benefits. And if you normally pay money to a vendor, so if you're going to pay a medical bill, or you're going to pay a transportation bill, or you're going to pay their phone bill or car insurance or something, then you pay that directly to the vendor, the insurance company, to the doctor, to the place you're buying the vehicle. You don't give the money to the beneficiary and then let them purchase the item or pay the bill, because that's treated as unearned income to them. Sorry, that went right out of my head. But if you do pay for food or shelter out of the trust, then the in-kind support and maintenance rules under SSI apply, and that would reduce their SSI only a third under the presumed maximum value rules. So some people will say it's worth having the trust pay their rent every month and lose a third of their SSI, because that's $300 and something, and you can't rent any place for $300 a month. And so some people choose to trigger that. But now if they're eligible for an ABLE account, the trustee could move the money into the ABLE account and then pay the rent from there and not have any reduction in their SSI. So you can use the vehicles together to take advantage of the broader qualified disability expenses under the ABLE account rules than under these trust rules. And there's a very specific definition of shelter, which is here. It's rent, mortgage payments, real property taxes, heating, fuel, gas, electricity, water, sewage, and garbage collection. And that's why you see in the next slide, the next line, they could pay phone bills, they could pay internet, they could pay anything, so shelter isn't every quote utility coming into the place. They're very specific utilities. So internet, phone bills, the car insurance I mentioned, and that's what I spaced a moment ago, is you could buy a vehicle for them if they're able to have a vehicle, but you would have the trust. You would have the vehicle in their name, but you would have the trust as a lien holder. Even if you paid cash for it and there's nothing owed, DMV doesn't care. You put the trust down as a lien holder on a vehicle, and that prevents them from having somebody talk them into changing the title, or them selling it, which would cause them problems. And then I've had this happen where they wreck the car, then the insurance comes back to the trust and the insurance payment doesn't go to them. And then as a trustee, you can discuss the appropriateness of continuing to buy vehicles for them. Yes, so right. Yeah, you can have more than one trust, but you have to coordinate. If you could have a special needs trust, you could have a pooled trust, you could have an ABLE account, but you just need to make sure you coordinate who's paying what from where.
Hey, Amrit, this is,
let's see.
Can you hear me? This is Steve Shadell.
Yeah.
Hey, this is going back to the ABLE account. I don't know if you want to go back to it now or at the end of this segment. One more slide.
One more slide?
Yeah.
Or the other way? This way or that way?
Says you can't use the ABLE pretty much. Like my son gets Social Security, SSA, and paycheck. So we can't throw things into an ABLE account to keep them below the $1,000. Is that what that says?
Well, you could use it to keep you below the $2,000 resource limit. That's what you want to use. But depending on what kind of Medicaid that he's on, there is also a monthly income limit. So if you make too much income, you can lose your Medicaid eligibility. And so what this is saying is you have to use one of these other trusts, a special needs trust, a pooled trust, or the Miller Trust. We haven't gotten to the last two yet. You have to use them to reduce the income below the income limit. I know for refused cash Medicaid, the income limit's $1,751. So that means that he's making enough money that he's not asking for APA, adult public assistance, cash assistance, but he's getting APA related Medicaid. And so if you add his Social Security unearned income plus his paycheck, gross numbers on both of those, and you exceed 1751, then you need to be using one of these other trusts for the amount that puts them over the 1751.
Okay. Yeah.
Okay.
Okay. Thank you.
Yeah, but if he's only making, $1,200 a month or something, you could stick all that money in the ABLE account because you don't have an income issue. You just are trying to keep under the $2,000 resource limit. All right. And then, so on the special needs trust, these are called first party special needs trusts because they contain the assets that belong to your kids, their income, their Social Security benefits, the inheritance that went directly to them, gifts that family members have made, whatever it is, a settlement from a personal injury, those are their funds going in there. And so that is why, Medicaid says we'll disregard their assets now, but when they die, will come back in and require you to pay back up to the amount of Medicaid provided. And so, as I mentioned before, nothing can be added after they turn 65 to the special needs trust. That's just a limitation in the federal statute. But if there are assets in there, can continue to grow indefinitely and be used, however, for their benefit. You just can't put a new chunk of money in. You can't stick a new PFD in. Once they turn 65, you won't be able to fund the trust anymore. And it needs to be for the sole benefit, just specifying so it's not, again, wandering off to another family member or something. And then from a estate planning perspective, for those of you who are parents, that you can create a special needs trust in your will or a standalone special needs trust that you can give your assets to, or that other family members can name as a beneficiary of a life insurance policy or a portion of their estate. And those those trusts do not have to repay Medicaid because they were never the kids' assets. And so if your family does planning, then you'll never need to, you may never need a first party trust because you're not going to get the extra. They're not going to get assets going directly to your child that can't be dealt with another way. And so the pooled trusts are, as it says, similar to the first party trust, but there's no age limit. The age 65 doesn't apply. But some people use them for their kids because you may not want to set up your own special needs trust. So you can go join a pooled trust. You could go to a nonprofit that runs a pooled trust and join their trust. They literally have what's called a joinder agreement. So instead of going and seeing a lawyer and having a trust drafted, you go to the nonprofit pooled trust and you sign their joinder agreement. And the Foundation of the Ark runs a pooled trust here in Alaska. And there are a number of state pooled trusts that will accept Alaska residents. And there's a company called Secured Futures Trust. I believe it's in Arizona. And they have done quite a bit of business up here in Alaska. Yes. So the question, can Social Security funds go into a special needs trust? Yes. Because that trust could take assets or income. It's only the ABLE account that has the limitation that if you are trying to deal with excess income over the applicable Medicaid monthly income limit for the program that they're on, you have to use a special needs trust, not the ABLE account. Yeah, or a pooled trust. Yeah. Okay, I saw the thumbs up there. So, and the difference with the pooled trust from the regular first party special needs trust is that there, instead of Medicaid necessarily getting all the money, the nonprofit it's possible for them to retain a portion of the account in order to help cover the expenses of offering these accounts.
Yeah, and I was hoping you could maybe go into more detail about that. If part of a pool trust means in the death of the beneficiary that the portion might stay, what happens in the single trusts? What would be the difference?
So in the first party special needs trust, at the death of the person who is the beneficiary of the trust ceases to exist. And you as a trustee the trust is to be terminated and you have to what's called winding it up. So you probably haven't gone through this yet, but there is actually a trust and estate recovery division of the state of Alaska. And they will send you a letter saying, so the case will close when your child dies, the case will close, and Medicaid will send, the Trust and Estates Division will send out a letter saying, we understand you have a trust that you were using to have Medicaid eligibility. And so you trustee will be back in touch with you. And it normally takes them at least 60 days before they get back in touch with you because they are waiting for the last medical bills to come in. The providers apparently have that long, to submit bills for reimbursement. And so the then after, and I can tell you honestly, I just called them last year and said, my guy died 2 years ago. And his widow just called, and you've never come and asked for these trust assets. And she's wondering what's going on. And it just took her 2 years to call me and say, oh, by the way, they never called and asked for these trust assets. And so it's possible that they will drag you on and you may have to, but if you haven't heard from them within 90 days, then you should be calling them and pinging, say, hey, what's going on? When can I pay the bill and close this trust down? And so they send you a letter that says we paid, $87,364.52 for Medicaid for this person. And you need to send us as much money as you have in the trust, not to exceed that 87,000, blah, blah, blah. So if you have $100,000 in the special needs trust and you get a bill for 87,000, once you've paid that bill, you can actually distribute the money to other family members or whatever the trust says. When I do them, I ask people, if you were doing your will, what would you want this trust to say? Does it go to your kids? Does it go to, who does it go to? You go to your siblings, whatever. And that's what would happen if there is money left.
And I'm just curious, would that have to be outlined in a will, or is that outlined as part of the trust account setup or documentation?
It's simpler if you do it in the will, in the trust, because if it's in the will, if there's actually enough assets, which is more than $50,000 under current law, if there's more than $50,000 of assets, you would actually have to open a probate in order to distribute money under the will. Whereas if the trust says you can distribute the money, that if there's any money left after Medicaid is paid, then you can distribute that money to A, B, C, D. You can also give the person a power. So if your child is high functioning and may well have a family later, or have, you can actually give them a power that they can do a will and say what's called a testamentary power of appointment, that says when they die, what they want to have happen with it. And that keeps it open so that it's not being locked in irrevocably when they're, young, and then things change 20, 30, 40 years later. They can have a testamentary power of appointment. They can't access the trust directly while they're alive, but they can direct that if there's anything left when they're after Medicaid's repaid, that where they want it to go. And you can also, if there's money left after Medicaid's repaid, you could pay their funeral bills or repay whoever paid them. Because the odd thing about these trusts, as many things are with the government, that you could prepay for their funeral from the trust while they're alive, but you can't pay for their funeral after they die. So, it's a typical kind of government thing, like, what? But you can prepay for their funeral while they're alive. You go to a funeral home, buy a prepaid burial insurance policy. But once they actually are dead, you can't pay for their funeral expense at that point. And so just a little tip of things to spend money on. If you're got money burning a hole in your kid's pocket, everybody's going to die, even if they're 20 years old. They may want this, 40 years from now. It's one of those things. And that's another thing. The ABLE account allows you to pay funeral expenses, which you can do with these accounts after they're dead. So then I mentioned, if you do your estate planning or other family members do estate planning, then you can have these non-paid back third-party trusts. Let's see this chat. Okay, and so someone sharing here, I don't know if you can see when I opened the chat what it says. So a prepaid funeral is a very good thing. I've had many family members do that, so no questions after passing away or family worries during an emotional time. Yes, thank you. That's a really good point. So that, yes, it's so simple when everything is paid for. Yeah, personally, my mother didn't do it and we had to do everything. And my dad died and it was completely seamless. He'd even paid for the motorcycle escort from the funeral home to the cemetery. I mean, he had every single thing prepaid, and it was so much better. So yes, that's a good point. So a third party trust is also frequently called a supplemental needs trust, but or they have the same name, so it can be confusing. And the difference is whose money is in it. If it's your child's money, the person on public benefit, it was their money, and then we stuck it in this trust because it was over $2,000, that trust has to pay Medicaid back. But when it was never their money, it's your money, it's their grandparents, it's their aunt and uncle, their brother and sister, whoever, it's someone else's, a third party. It's somebody other than the person receiving benefits money, then these trusts don't have to repay Medicaid. And so this is what all of you need to have, because under the laws of intestate succession in the state of Alaska, if you died, your kids will get, if you're married, your spouse will get everything. But then when your spouse dies, it goes equally among all your kids. And that includes your adult disabled child or minor disabled child. And so you need to do some kind of planning, whether you do set up a account with a pooled trust, and then your will says X number of dollars goes to this pooled trust account that I've set up for Joey over here, or you set up one of these trusts either in your will or as a standalone trust that other family members can leave money to. And if your parents have set it up for your kid, you can, and it's a standalone trust, then everybody in the family could use that trust. It doesn't have to be every single person does one for them. And so, because if they're standalone and effective immediately, then they can be named as a beneficiary because the trust exists at this moment in time. It gets its own tax ID number, and you can name it on a beneficiary designation. Again, it still has to be for the sole benefit of the beneficiary, so it can't be just mashed in with, I'm putting everything in trust for my 6 kids. It's got to be, this trust has to be for that, your particular child who's on benefit. Distributions are discretionary rather than mandatory, so it doesn't say the trustee shall give Joey, $500 every month for spending money. It needs to be discretionary. The trustee can pay for things for the beneficiary if the trustee determines it's a good thing to do in the trustee's sole and absolute discretion. And so it's all, you're trusting your trustee to execute your wishes, but you have to be vague enough that there's no rights of demand that Medicaid could come in and say, hey, everything, these assets really is available to Joey. All these assets in the trust are available to Joey now. And so, as I mentioned before, the last bullet notes that the trust can fund an ABLE account to provide more flexibility for payment of shelter and basic living expenses. And so even though it's third-party money, it can then be funneled through the ABLE account in order to provide more benefits to the beneficiary without impacting their public benefits, improve their quality of life without impacting their public benefits. All right, so questions about the asset trusts, or did you ask them as we went along? So you got this pooled trust, this first party special needs trust, and then your estate planning special third party special needs trust. All right, so
excuse me, I'm a little slow. So if my son has excess income, that excess in over the 2,000 a month, it can go into his special needs trust, and then the special needs trust can throw money into the ABLE account. Is that legal?
Yes, though there's not a $2,000 a month income limit, there's only a $2,000 a month resource limit, because there's 2 financial prongs of Medicaid: income and resources. And so these trusts deal with the $2,000 resource limit. But they also deal with if they exceed the income limit for the program that they're on. And I'm
Okay.
getting ready to talk about Miller Trust. That's what we're going to do next. So let me go through that and let's see if it gives you any more clarity. And if not, we'll discuss it some more. Okay.
Got it.
All
Thank
right.
you.
So the Miller trusts are for excess income only, not for assets and resources. So if they've got, 10, well, we should have more than 18,000. So if they've got $25,000 saved somehow before they turn 18, then you can't turn around and plop that in a Miller trust. You could put 18,000 of it in an ABLE account, but then you'd have to join a pooled trust or set up a first party trust for the other 7,000 because you can't stick assets into a Miller trust. And I know it's confusing because you can stick income into the other asset trusts we just talked about. But the Miller Trust is an income only trust. It can only take monthly income, Social Security benefits, wages. That's essentially it. If there's some kind of annuity that's paying to them every month, that kind of income is what goes through the Miller Trust. It's not for savings. It's not for, random thing. It's not even, well, yeah, you can put your PFD in here, but it's not a good place to put it. But you can put your PFD in here, but actually Medicaid doesn't encourage you to put it in there either. And so you're better off putting the PFD in the ABLE account if they're eligible to have one. And so, but the nice thing about the Miller Trust is it can be used for, sorry, I set this here so I could turn it off as soon as it rang. But the Miller Trust can be used for all types of Medicaid eligibility. And so for the types, anything your kids are on, they can use the Miller Trust to maintain income eligibility. But the important thing is you can't use it for SSI or APA cash assistance. Because if you think about it, SSI, supplemental security income, and adult public assistance, cash assistance, are for people who have very low incomes. And so if they have other income, these benefits are going to get cut because the governments have decreed that people should be able to live on $943 a month, the feds have. And the state says, well, we'll give them an extra, $365 or something a month. So the pay standard is still lower than is, really reasonable. But if you are exceeding that pay standard for SSI or APA, you cannot use a Miller Trust to keep those benefits in place. They are just going to cut those cash benefits. They're not going to cut the Medicaid. They're just going to cut the cash benefits, and it's going to be replaced by whatever this other income source is. This is, as I say here, the monthly income limits vary by the program. I'm happy to give you links to the appendices, but everything's online. The Medicaid manuals are all online, and these numbers are in the appendices. Addendum 1 to each of the manuals has the numbers in it for income, and actually for resources too. And then we also use these with my elderly clients. We use these for periodic, like quarterly native stock dividends, because you can only exclude $2,000 a year of native dividends for income or resources. So if any of your kids are inheriting anxious stock from a relative, that's something you're going to need to be alert to, that if they're going to start getting large quarterly dividends or even regular dividends, once they reach 2,000 in a year, those dividends have to go through some other vehicle because now they're over the income limit for the year, because once they get 2,000, Medicaid starts counting. And so if that combined with their regular monthly income puts them over for the program, it has to go through here. And some of those dividends are quite large. There'd be $2,000 or $3,000, which is more than most of the Medicaid program limits. So you'll have to pay attention if you start having kids inheriting stock. The thing, remember at the very beginning, I talked about how they look at resources only at 12:01 a.m. on the first day of the month. The difference with a Miller Trust is it can be established and funded anytime prior to the end of the month for which you want income eligibility, and it's retroactive back to the first of the month, which if you think about it makes sense because not everybody's paycheck arrives on the first. So the money's going to drift in over different days in the month. Some people will even get paid on the 28th or 29th. And if they put the money in the Miller Trust, they're retroactively eligible for the whole month for their Medicaid. You'll see usually we use a language that says it's an irrevocable income trust, but it's only irrevocable month to month. It's not a permanent assignment of income. So if they decide to go off of Medicaid, they just stopped funding the trust. But any money that's already in the trust that hasn't been spent has to stay in the trust. Or you could get a court order terminating the trust, but then normally Medicaid is going to be repaid from the trust. Again, only up to the amount that they've spent. And so the Miller Trust give a allowance, a personal needs allowance to the person every month to pay for food and shelter, and then other things, clothing, haircuts, toiletries. And so if your child needs a Miller Trust account, or you choose to use a Miller Trust instead of one of the pooled trust or the first party special needs trust, then they need to have a personal bank account in order to hold and manage the personal needs allowance funds. So if you're their legal guardian, it would be your guardianship account is their personal needs allowance, their personal account. I note here in the third bullet for blind or disabled beneficiaries, including residents of ICF or MR institutions, the personal needs allowance / income exclusion amount may be increased by the amount of income needed to fulfill an approved plan for achieving self-support. So if your child has a self-support plan that's been approved through the appropriate agencies, that extra money can be released every month from their income to cover that. Again, you have to pay vendors directly, not give money to the beneficiaries. And because lawyers write the statutes, generally attorney fees for preparing the trust, as well as accounting fees for maintaining the trust if you need to file tax returns, which you really shouldn't, and those are also allowed on the other types of trusts too. Those are kinds of disbursements that can be made. Okay, so now questions about Miller Trust? Oh, you're back. Thumbs up. Okay.
So I'm sorry, it's kind of a redundant question. There is no stopping. I just want to be clear. You can have an ABLE account, a Miller Trust, or one of the other special needs trusts, and nothing is stopping you from doing all three, correct?
Right, you're warbling a little, but I think you're asking, you can have an ABLE account, a special needs trust, and a Miller Trust, and the answer is yes, but you only need the Miller Trust if your income exceeds the program limits for the program that you're on. Otherwise, you would probably just have an ABLE account in a special needs or pooled trust.
Thank you. Can you talk a little bit about how to actually set some of these accounts up? I know Miller Trust, for example, at least from my understanding, is that it's pretty complex to set up. But I don't know about the other ones, or if they're easy or difficult, or if you need, a lawyer or someone to help you do that. Can you talk a little bit about that, please?
Yes, so Alaska is not one of the states that has provided forms for these trusts. And so, yes, they normally have a little pamphlet that says, here, you need to go hire a lawyer because you need, I think the letter is called like qualifying trust referral or something. And it says you need to go hire a lawyer because you need a Miller Trust, a special needs trust, or a pooled trust. And so, well, the pooled trust, you don't have to hire the lawyer, but yes, you have to have a lawyer draft these documents. They're not something that's a fill in the blank form. And I would like to say yet. I mean, I hope at some point that they can be, but it's not. Medicaid doesn't want to be in the business of giving legal advice. And so they force you out to lawyers to advise you about their program. They only want to look at their manual and say, do you, you know, have you jumped through all our hoops? And one of the hoops we're checking off is Miller Trust or qualifying asset trust. You know, if you got the right trust, we'll keep moving your application forward. And so you have to have a lawyer draft the trust document, and then you have to set up a bank account for the trust. With Miller Trust, you use the social security number of the person. With the special needs trust, we actually get a separate tax ID number for the trust. And, you know, this is something in my office, we do all these pieces. So, and then all the trusts, Miller Trust or special needs trusts, have to be registered with the court, the state of Alaska. And it's just, I don't know why they decided that, but well, it's just the law. When there's a trust, it has to be registered, and the registration form gives the name, address, and now the telephone number and email. They amended the form last year to add those of the trustee. It used to just have name and mailing address of the trustee, but now it's also got your phone number and email address. And then they charge $50 for that trust registration. Global Credit Union requires you to have that trust registration form from the court before they will open a bank account. Most of the other banks, you just take a copy of the trust document to the bank, show where it says who the trustees are, which should be you, you know, generally the parents are the trustees or the legal guardians, and then they open the bank account in the name, you know, it's all spelled out there. And once the accounts are open, then the question is, how do you fund them? So with a special needs trust, wherever the money's coming from, it's going to be directed into that trust. With the Miller Trust, you have to decide if you're going to change the direct deposit from their personal account to the Miller Trust account, and how difficult is that to do? Or are you going to open the Miller Trust at the same bank that they currently get their Social Security direct deposited, and then you're going to set up an auto transfer at the bank to move that money to the Miller Trust each month? And so
Okay.
Did that make it seem less complicated?
I'm not sure if it did, but at least I understand it a little better. Is an able account, setting up an able account, similar, or is that more like setting up a bank account?
Well, the able account, I have heard different versions from different clients. And so I can't set one up. You go onto this website, and then it starts asking you all these questions. And some people are really intimidated by the questions, or they don't have the right, quote, right relationship. So like they got a power of attorney and they don't have a guardianship form, or they have something that then they keep getting run around in circles by the Fifth Third Bank. And so, but no, that's entirely lawyer free. It's a contract between you and the able account provider, whether it's the Alaska Able or you go someplace else and it's whatever bank or entity they've contracted with. So I think that was actually the end of my presentation, doing odd things now with my screen. Sorry about that. Yep, just has my little bio at the end. So, I mean, I had some slides I hid about like all the different kinds of Medicaid. I decided that might be too much. So, but the working disabled was the only one I pulled out to make sure people knew that's something that I have had a couple of clients find was the solution to their earning problem, was changing. It wasn't an earning problem so much as all the extra money they made, their waiver required them to pay a cost of care, and all the extra money they made, Medicaid then sent over to pay cost of care. So then they weren't making any money. They didn't have any extra spending money. And so by switching to the working disabled buy-in and paying a premium, they got rid of that cost of care obligation and were able to keep more of their income for their own use every month and keep the Medicaid benefits that they needed in place. So it can be a really good program if it's something that, if they're able to work and want to be able to enjoy the fruits of their labor. Okay, well, I can stop sharing if you don't have more questions. Oh, Steve, I see your hand again. Okay.
Yeah, Amrit, you had mentioned that for a special needs trust, there's a new regulation to get an email and a phone number in. Is that to this? How do you go about doing that? Because you said it just
Oh,
happened.
well, it's not the special needs trust. Let me see if I can open this up. Since I'm not sharing, it will make people busy it's the new trust registration form for the court. But it's the trust registration form with the court. So if you've already done a trust and registered it, you don't need to worry about it. But if you haven't, then you will have to fill in you will have to now provide. And I haven't actually looked to see if they're posting it on the website or if you'd have to really physically go down there. And maybe they ask for that information, but they still don't post it publicly. So they ask for stuff that they don't always make accessible on court view to the general public.
So that's Alaska State Court.
Yeah. Yeah, it's a P200 trust registration form. Well, if only I knew where I stuck it on my hard drive. It should be like 4 places and I'm not finding it anywhere. Though it's probably right in front of me and I'm just not seeing it.
But if you've already filed your trust like 2 years ago, you don't have to update
No,
it.
no. And thank you for mentioning that. They have in fact made an update form. It used to be until last year that we would always just like write the word updated next to the registration of trust form because they didn't have a form to do that. And now they have done an update form. So if you move and need to change your address or you resign and another trustee comes in, then you now do this updated registration of trust form because it references the original trust registration number and it avoids you having to pay another $50 filing fee to update the information. And so they now have that form. If you do want to change something, you want to use that. So, okay, is
It's
Lisa
for
cool?
St. Patrick's Day.
Oh, right, it's racist. So
It's a
I
little-
think there aren't any more. Oh yes, look at that. It's nice we have one holiday after another, so that there's different craft activities to be done. So, okay, but I think Lisa, if there's no more questions, we can call it a night. So.